हेलो एवरीवन, वेलकम टू लीगल प्रॉक्सी। आज हम बात करेंगे वन ऑफ द इम्पॉर्टेंट टॉपिक अंडर कोड ऑफ सिविल प्रोसीजर, दैट इज जुरिस्डिक्शन। एज यू ऑल नो दैट जुरिस्डिक्शन बहुत ही ज़्यादा इम्पॉर्टेंट है फॉर एवरी केसेस। Therefore, it is necessary to understand the jurisdiction to institute any civil case. To understand the jurisdiction, it is necessary to understand one Latin maxim which is very important to understand the concept of jurisdiction. That maxim is ubi jus ibi remedium, which means there is a right, there is a remedy. इसका मतलब ये है कि जहाँ पर राइट है वहाँ पर रेमेडी है। अगर राइट होगा और रेमेडी अगर नहीं हुआ तो वो हो ही नहीं सकता, बिकॉज rights and the remedy are the two sides of same coin and they cannot be separated from each other. So जहाँ पर right रहेगा वहाँ पर remedy रहेगा, उसको separate नहीं कर सकते। जैसे coin में head और tail रहते, एक coin में inserted रहते, one side, two side in a same coin which cannot be separated. अगर हम उसको separate करते हैं then coin will lose their value. So similarly, अगर हम राइट को रेमेडी से सेपरेट करते हैं देन देयर विल बी नो पर्पज ऑफ राइट्स एंड नो पर्पज ऑफ रेमेडी. देयर विल बी द बेनिफिट व्हेन देयर विल बी राइट्स एंड द रेमेडी. Similarly, a litigant having a grievance of civil nature, then that person has a right to institute a civil suit in a competent civil court unless it's barred by any statute. अगर किसी को कोई ग्रीवियंस है वो रिलेटेड टू सिविल नेचर, देन उसके पास राइट है कि वो सिविल सूट इंस्टीट्यूट कर सकता है और वो भी सिविल कोर्ट में, एंड अनलेस इट्स बार्ड बाय एनी स्टैट्यूट. लेट्स सी द कॉन्सेप्ट ऑफ जुरिस्डिक्शन. व्हाट डज इट मीन? जुरिस्डिक्शन मीन दैट इट इज ए पावर और अथॉरिटी ऑफ ए कोर्ट ऑफ लॉ टू हियर एंड डिटरमाइन ए कॉज और ए मैटर. It is a power to entertain, deal with and decide a suit, an action, petition or other proceeding. So कोर्ट के पास पावर है कि वो मैटर डिसाइड करे and come to the conclusion and provide the judgment, decree or order. So the question arises that if court has no inherent power, then on that time क्या होगा? So if the court has no power of jurisdiction, then it cannot be created because it is the power of the legislature to create or enlarge the jurisdiction of the court. So if decree or judgment, order, etc. passed by court without having jurisdiction, then in this case that order would be considered as a quorum non judice, which is a Latin maxim which means that it's not before a judge. It was held in the case of Sushil Kumar versus Govind Ram in 1919. So the question arises that if two or more courts have jurisdiction, then on that condition में क्या करना होगा? So on that condition, then it is open to the party to select the particular jurisdiction. If two or more courts have jurisdiction to try the suit, then उस condition में it is open to the party to select the particular jurisdiction. So usually हम ये देखेंगे basis of determining the jurisdiction under that concept कि jurisdiction कैसे decide करते. So usually if अगर दो से ज़्यादा जगह पर अगर jurisdiction fall करती है, then it's depend on the party to decide which jurisdiction they want to take. Like अगर एक person है महाराष्ट्र का है, if a दूसरा person गुजरात का है, and they came into an agreement in मध्य प्रदेश, so यहाँ पर 3 jurisdiction है स्टेट का. So it's depend on the party to which jurisdiction they want to select. So to understand the jurisdiction, even we have to understand that what does it mean of the particular things under jurisdiction, like lack of jurisdiction and irregular exercise of jurisdiction. As you all know that a court has jurisdiction to decide right as well as wrong judgment. Wrong judgment means if it's against the plaintiff or defendant, they consider as it's a wrong judgment. So if they thinks that it's a wrong judgment, then they have to take course prescribed by law for setting matter right. उसके लिए procedure established है that if you are not accepting that decision, you have to go with the procedure which prescribed by law, like a revision, appeal in the higher court, so that you can claim the rightful judgment, order or decree. If you are not going that way, then the previous order, the order which passed by, which you don't like that order, it would be considered as the final order. Now chaliye basis to determine jurisdiction. So jurisdiction can be determined on the basis of the case which put forward by the plaintiff in his plaint and not by the defendant in his written statement. Suppose there are two persons, one lives in Maharashtra and one lives in Gujarat. So it's depend on the plaintiff to decide which jurisdiction they want to take. They can file their plaint in Maharashtra as well as Gujarat, and after that court will summon the defendant within a 30 days. Under 30 days, defendant need to write a written statement, and under written statement the defendant cannot claim the jurisdiction, benefits of jurisdiction according to their benefit. उसके साथ साथ हमें ये भी जानना जरूरी है jurisdictional fact. So jurisdictional fact is nothing, it is considered as a condition type of things which need to fulfill for the existence of jurisdictional fact. Jurisdictional fact, jurisdiction of a court, tribunal or authority may depend upon fulfillment of certain condition or upon existence of a particular fact is called as a jurisdictional fact. Means it's depend on the condition. अगर वो condition fulfill होता है, then only it would be considered as the jurisdictional fact, and then only the court will get the jurisdiction to institute the matter. If the court doesn't have jurisdiction, if the jurisdictional fact does not exist, the court cannot act. अगर नहीं है कोर्ट के पास, अगर jurisdictional facts does not exist, अगर exist नहीं करता है, then वो कोर्ट के पास jurisdiction नहीं है कि वो उस मैटर को वो entertain कर सके. अगर कोर्ट assume करता है wrongfully that existence of jurisdictional fact और वो order और decree और judgment पास करता है, that can be questioned by a writ of certiorari. And certain cases where jurisdictional facts is important, like if I give you one thing like bouncing of check. As you all know that for the bouncing of check, it is necessary that after the bounce of check within a 30 days, it is necessary to give a notice to the party who bounced the check. And without giving notice, you are just directly going and filing the plaint. Then the court won't be having jurisdiction because it is necessary to give the notice and wait for the 15 days. And after 15 days, within a 30 days, you have to write the plaint. So similarly, to claim the jurisdiction of the particular court, it is necessary to follow the condition. Now let's see decision as a jurisdiction. Whenever the jurisdiction of court is challenged, the court has inheritance jurisdiction to decide the said question whether it has jurisdiction to entertain the matter which has come before it. So अगर कोर्ट के पास क्वेश्चन अराइज होता है कि कोर्ट के पास whether the court has inheritance jurisdiction to decide the matter, then on that condition the court has inheritance right jurisdiction to decide that question, that whether the particular court has the jurisdiction or not. Jurisdiction of tribunal cannot be challenged by the writ of certiorari if the statute has given power to tribunal to decide and determine the preliminary facts on which its jurisdiction depends. But it can be challenged under the certiorari if the statute has not given such power to entertain. अगर jurisdiction ट्रिब्यूनल को दिया गया है कि ऑन दैट पर्टिकुलर मैटर यू हैव द जुरिसडिक्शन, देन ऑन दैट मैटर ओनली ट्रिब्यूनल कैन इंस्टीट्यूट दैट पर्टिकुलर सूट एंड एंटरटेन दैट सूट. अगर स्टेट्यू में नहीं है देन ट्रिब्यूनल कैन नॉट एंटरटेन दैट पर्टिकुलर सूट. अगर कहता है देन सेम रिट वी विल यूज. थैंक यू फॉर वॉचिंग दिस वीडियो. आने वाले टाइम में हम CPC के पूरे सीरीज लेकर आएंगे. उसके साथ साथ हम लॉ रिलेटेड वीडियो भी लाएंगे, लॉ रिलेटेड सब्जेक्ट्स टॉपिक्स के रिलेटेड. थैंक यू. लाइक, सब्सक्राइब एंड शेयर इट.